EB-2, Green Card Delay. Smart strategies while you wait.
Hi, I am Attorney Edwin Fogam. I have practiced immigration and other areas of the law in the United States for the past 28 years. Today, let us consider the situation where an employment-based petition has been approved. That is, an I-140 petition was filed and has been approved, but the priority date is not current. This happens a lot because, apart from extraordinary ability, most employment-based visas require that the visas be available and current pursuant to the State Department Bulletin and so on. So what happens in this situation? Now, first of all, it depends on the status of the beneficiary or the applicant. There are two strategies to consider. The first is a applicant should be creative in changing from a non-immigrant status to another non-immigrant status. I'm assuming that if the applicant filed within the United States, it means they are in some not valid non-immigrant status, such as F1 or even OPT or H1B. Now, they can creatively move within non-immigrant status while waiting for the priority date to become current. For example, they could move from F1 into H1B, could move from H1B to L, or even from F1 to L, and so on, depending on their qualification. In some extraordinary cases, they can still apply for extraordinary abilities, but that is one strategy to be used. It is very important when using this. In fact, we have had some clients who have gotten back into other programs just to keep their F1 status for the period of time to get the visas to become current. And some have even got into postdoctoral programs and lesser programs as well. So that is the first strategy. The second strategy is to work around consular processing to determine how you can go out and wait for the visa to become current, and then you come in as a permanent resident. This is very important. It is very important that while you are exploring this strategy, you should keep in mind the bars to admissibility. That is the 3 years and 10 years bar. Not generally, if you have been out of status for more than 6 months and under 1 year, you have a 3 years bar, which means you have to stay out for 3 years before coming back into the United States. If you have been out of status for overstay for more than 1 year, you will be barred for up to 10 years before coming back into the United States. Of course, these can be waived, but again, the question is, do you want to get into that fight? So these are the two strategies to consider. When you are thinking of consular processing, you can also think of going out and re-entering with a B1, B2 visa. However, at that point, you have to be careful of dual intent, because if at the time you're coming back, you have the intention of becoming an immigrant and that is not clearly disclosed, you may have a problem with that. So these are the things you should consider when and if you have a valid approved I-140 petition and you are waiting for your visa to become available. I hope this was helpful to you. If you have any more questions, please feel free to contact us. Our number is 301-608-1555. You can also send us an email to info@fogamlaw.com. And always remember to understand the system, don't fear it, work with it, and benefit from it. We can help you. Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.